Jason Jones against the Attorney General, Trinidad and Tobago, and others.
My lords, my lady.
Good morning, Mr. Logan.
Good morning, my lord.
Can I raise a couple of housekeeping matters with you?
Indeed.
We have had a number of documents lodged, and bundles of documents lodged in the last day or so. We've got, one of them is an appellant's schedule of the
Yes, it's
the way in which the legislation has developed over time. I'm wondering, is that an agreed document, or is it controversial?
I think it's now agreed. I saw it was amended last night, but from a brief perusal, I think you can take it as agreed.
Right. Well, obviously you can let us know if there is a problem, but we'll proceed on that basis in the meantime.
It will be the second version that you received last night, not the first version. So I don't know.
We only received one version.
Yes, we've only got one.
We had some slight minor amendments. We emailed it last night, but we have hard copies.
This is the one that what I'm talking about is the
the one with the track changes.
The document that's headed up Offences Against the Person, Ordinance, etc. Page 2436.
Yes. Yep, that's correct.
Right. Once that matter dealt with in the meantime, we also received two different versions of something called an agreed supplemental bundle of legislation. Or, at least we got two separate versions of it. I don't actually know if there are any differences between them, but I presume there must be.
I hope not, but the safer option would be to rely on the latest version of.
Right.
But I rather suspect there wouldn't have been any significant change.
Right, well, we'll rely on the one that came in second in that case. Fine. Those were all the matters I had to raise.
Did you say you had hard copies?
Yes, and we do, yes. And with the board's leave, it might be much more productive if we just pass that up.
Because there's doubt as to which.
Much obliged.
Yeah.
Yes, of course.
Yes, I've asked her. Yes, I did ask. That was the first thing I asked. And thank you. Yes, he thinks it is. So we can proceed on that basis.
I'm grateful to you, my lord.
Yes. Well, Mr. Logan, obviously we have a fairly tight timetable today. You can take it that we have all read the judgments below and the written cases, and we've been discussing the issues, so you can launch into the middle of the argument if you like. I'm
grateful, my lord. My lord, just for the record, may I just enter the appearances?
Yeah.
My lord, I appear for the appellant in this matter, and with me Miss Amanda Clift Matthews, Miss Kate Temple-Mabe, Mr. Peter Lavrak, and Mr. Ganesh Sarup, and we were instructed by the firm of Travers Smith. My learned friend, Mr. Peter Knox, leads Mr. Robert Strang, and they're instructed by Charles Russell for their respondent.
Yes.
My lord, this appeal concerns a narrow but very important question concerning the scope of the savings law provision in Section 6. It really has to do with what is the true purpose and scope and ambit of that clause, and whether constitutional protection afforded by Section 6(2) of the Constitution to an existing law automatically attaches to a subsequent Act of Parliament which repeals and replaces that law, and whether that constitutional immunity thereafter continues to attach to successive amendments and legislative replacements of that enactment. May I at the onset indicate points of agreement and disagreement? The first point is, I don't think there's any dispute between my learned friend and I that Sections 13 and 16 of the Sexual Offences Act breaches the rights protected under Sections 4 and 5 of the Constitution. that in any event is the finding of the Court of Appeal. And we can find that at page 1632, paragraph 72, where Justice of Appeal Barrow in the majority judgment says, but for the savings law clause, it's clear that it violates the fundamental rights. The second point is that I think it doesn't appear that there's any dispute that this law that we're concerned with falls to be governed by Section 6.1. The battleground really is Section 6.2. Section 6.1 doesn't appear to be to feature in this matter. And the reason, of course, is that both Sections 13 and 16 derogate further from the protection for fundamental rights in the Constitution than the previous law did, and that falls smack into the category of 6.2. The third point I wish to make is that there is no cross-appeal by the state in this matter. They do not seek to vary the order of the Court of Appeal, and therefore we say there is agreement between the parties that the further derogations in Sections 13 and 16 are not reasonably justifiable in a society with respect for the rights of the individual under Section 13 of the Constitution. There being no cross-appeal, we say that that must be accepted, deemed to have been accepted by the respondents, and therefore we're concerned primarily with the Section 6.2 savings law clause issue.
Yeah. So there's no issue arising, there's no live issue any longer under Section 13 of the Constitution?
As far, from the appellant's perspective, we say no, because there's no cross-appeal, and that's the finding of the Court of Appeal.
Yes.
Well, that's not quite our position. We just say you can get to the same route as Section 6.2 by Section 13, but disapplying all the further derogations in Sections 13 and 16 of the Act.
Yeah.
So it's an alternative, but we don't seek to restore the full penalties imposed by the original 1986 Act or indeed by later legislation, but we do say you can get to the same route by Section 13 as long as you disapply all the further derogations.
So that sounds as though you are going to be making submissions to us in the alternative to your submissions on Section 6.2.
Yes, I will be focusing on Section 6.2 mainly, but I will also, you'll have seen from our written case, we do have a section at the end which deals with the alternative case on Section 13. Yes. But there's no cross-appeal in the sense we are not seeking an alteration of the order.
No, I see. Yes, Mr. Rowland.
Yeah. My Lord, the other point I want to make, point 4, is that the death penalty line of cases culminating in Chandler are of limited assistance to the board because they all concern a 6.1 type situation where there was no extra derogation to the existing law. Mm-hmm. And finally, I think we can take it for granted, certainly in our research, that this is the first time the board has been asked to deal with a Section 6.2 case. So the novelty and fundamental constitutional and public importance of the matter is one we wish to highlight. The other preliminary matter I want to draw to my Lord's attention is that the respondent filed no evidence in this matter, so that there is no opposition to the evidence, challenge or opposition to the evidence of the appellant, and of course that has implications for their ability to launch an argument and reasonable justification as well, we see. I'd like to start, my lords, by taking the board to Section 6 and why we say this is not, in fact, a case where Section 6 applies at all. Our position is that this law, the amendment, this law is a new law. It is not a repeal, reenactment with modifications that falls to be governed by Section 6.2. There are a number of features about the Sexual Offences Act that demonstrate that it cannot be and was not in any sense a reenactment of the old law. It was a law that was intended to overhaul and reframe the sexual offences in a way that reflected a more up-to-date view of the type of sexual conduct that should be the subject of criminal sanction in a modern Trinidad and Tobago society. It really was a complete reconsideration of sexual offences. And to make good that, my lord, can I take you to the handout we've just passed out, which contains the track change version of the offences.
Yeah.
We start with the first page, which is the 1925 Offences Against the Persons Ordinance. And the very first thing that strikes us is the subheading, unnatural offences. That dovetails nicely into the wording of Section 60, which is that whosoever shall be convicted of the abominable offence of crime of buggery, committed either with mankind or with any animal, shall be liable to be imprisoned for a term not exceeding 5 nor less than 2 years, with or without hard labour, and if a male, with or without corporal punishment. Now, the mere fact that it would be lumped together with buggery with an animal tells us the thinking, the prevailing thinking at that time. And of course, Section 62 deals with gross indecency. Any male person who in public or private commits or is a party to the commission of, or procures or attempts to procure the commission by any male person of any act of gross indecency with another male person shall be guilty of a misdemeanor and upon being convicted 2 years with or without hard labour. The next page brings us to the law as it stood in 1976, which is the state of the saved law that predated the Constitution. There was an amendment to the 1925 ordinance by Ordinance number 14 of 1939. I have to say that part of the reason we had to supply this so late is because we have not been able, neither party has been able to find these ordinances. Mm-hmm. And we took it from the Court of Appeal's judgment, and we inserted the relevant pages. We assumed that the Court of Appeal got it right because we have not been able to find those ordinances. But all it did in any event was the minimum sentence of 2 years set out in Section 60 appears to have been repealed, and they deleted the option of adding corporal punishment to a male offender's sentence. And you'll see that from the bits that have been crossed out. But they maintained in any event the unnatural offences. But that was the state of the law that predated the Constitution.
So the second page is as at 1976.
That is correct. That is the state of the existing law prior to the enactment of the Constitution in 1976 that we are concerned with. Now, a few points about the way the law, as it then stood. You will notice that there was no definition of buggery. There was nothing to say what the actus reus meant. They retained the unnatural offences categorization, and in that regard, can I just show the prevailing thinking at that time by asking the board to turn in the electronic bundle to page 221. And at page 221, this is the judgment of Justice Rampasad, and it's an excerpt at paragraph 18, which begins at 220, and he's quoting Justice Michael Kirby, and this is what he says at page 221. I'll take it just from the second paragraph. Sodomy was perceived as an offence against God's will, which thereby attracted society's sternest punishments. Initially, it seems, the offence was not limited to sexual acts between men. It could include any sexual conduct deemed irregular and extend to sexual intercourse with Turks and Sakrans as with Jews and Jewesses. Although the ideas were traceable to the Old Testament and the Jewish rabbinical law, the offences were reinforced by a Christian instruction that associated that sexual act with shame and excused it only as it fulfilled a procreative function. Sodomy was a form of pollution. The history of the 11th and 12th centuries in England and in Europe, including many instances of repression targeted at polluters such as Jews, lepers, heretics, witches, prostitutes, and sodomites. Yeah. Now, the point I wish to make here is that the etymological origin of this word and this offence is such that it was rooted in ecclesiastical law at a time when the church and the state were one. But more importantly, it prohibited, as Orthodox Christian theological positions do, all forms of non-procreative sex. But it also extended, as you will see, to interracial or interreligious sex. And, I mean, had this remained the case and the law not evolved, I mean, I hasten to say there would have been no Jude Bellingham to score for England recently. But the short point is...
Are you saying that the crime of buggery in the 1925 legislation had, at that time, this extended meaning?
No, I'm not saying that it carried that, but I'm showing the historical origin and concept of the offence.
To understand.
Yes, certainly, my lady. What I'm doing is showing the historical origins and the evolution of the offence, because it's important to understand what the parliamentary intervention in the Sexual Offences Act in 1986 signified, and that is why I'm taking you to it. I also take you to show that the offence was one that the ramifications of it was such that the umbrella covered a wide variety of situations, including interracial and interreligious sex. That was considered to be an unnatural act, that was offensive to the Orthodox Christian position, just as well as all forms of non-procreative sex. And then the whole point is the offense was linked to God's will and the natural order as dictated by Christian theology. It legitimized miscegenation, and it is reminiscent of, the same kind of discrimination with the same common denominator about the differences in humanity that would have underscored Hitler's quest for racist supremacy that, but for World War II would have probably thing. That's why, for example, he found that homosexuals were a threat to the Aryan race. If one takes it, for example, in modern context, the contraceptive pill in 1927, that would have been considered unnatural and would have been considered something that would be against God's will and the natural order, because it was divorced from procreation by the ingestion of synthetic hormones. And I just mentioned that to show how important the historical origins, conceptually, philosophically, and as a matter of policy, were in relation to this offense. If we turn the page, we come to the 1979, post the enactment of the 76 Constitution, we come to the 79 position where there's a minor change where they inserted a subsection 2 to section 60, simply to say that a person convicted of buggery with a person under the age of 14 shall be liable to imprisonment for a term of years, life or for a term of years. We then come to the 1980 consolidation, which is on the next page. And they changed the word sodomy to buggery, and other than that, it's unremarkable changes. And we then come to the next page, the Sexual Offences Act. Now, the Sexual Offences Act, as you will see from the track changes, the visual on it tells a story by itself. It really is a case of a picture tells 1,000 words. We say that when the Act declared that this was an act to repeal and replace the laws of Trinidad and Tobago relating to sexual crimes and procurement and abduction and prostitution and kindred offences, Parliament really meant what it says, which is it was an act to repeal and replace, not an act to amend, not an act to modify, but an act to repeal and replace. It was a complete overhaul. And we say The purpose of the save law provision was to protect and preserve laws that were made outside the constitutional framework post the grant of independence. Before, it was meant to protect laws that existed at the time the Constitution came into existence. But it did not, there's an important caveat. Parliament had the power to intervene and review these laws. And as long as Parliament chose to intervene, the question is when does Section 6 bite? We say that will have to be decided on a case-by-case basis. There's no exhaustive formula, but we say in this particular case, on the exceptional factual matrix of this case, we say Parliament clearly intervened, reviewed the law some 61 years later, reviewed all sex crimes, and in light of the current prevailing climate of social and political values and judgments, Parliament intervened to redraft the socio-political template for these laws. Can I take the board to page 3449 of the electronic bundle?
Sorry, say that page again.
3449, 3449, my lord. And if I pick it up at the bottom of the page, this is the words of the then Attorney General in piloting the bill, and this is what he said at 3449. Having said that, the purpose of this bill is to provide us with a comprehensive code dealing with sexual and indeed related offences, as the long title shows, primarily amending the Act. And indeed, the second objective is to modernize our law, to bring it up to date with current thinking in society, moral and social thinking, indeed, to take into account the procedures and practices which now obtain in the courts in dealing with these offences, and to try to see in what way they can be improved. At the core of this bill, the question of to what extent must the criminal law deal with sexual conduct, conduct involving questions of morality and indeed public standards of decency. The question is not one for which there can be a simple answer. It is not one for which you will find an answer that all agree on. We know that while we may have the currents of morality in a society, we may find one stratum, etc., etc. The short point is, I mean, if we read on to the next two paragraphs, it is clear, abundantly clear, that in framing the debate for the House, this was a major overhaul and something to be reconsidered. That is why the significance of the repeal, if you repeal and put a new bill before the Parliament, Parliament during the debate, if it wished, could have easily abolished, if it wanted, the offence of sodomy altogether. It was because they had repealed the old law. So the point, that is to illustrate that this was a fresh, complete reconsideration by Parliament of the provisions. Now, we go to the Parliament was, so when Parliament intervenes under Section 13, it takes political ownership and political paternity of the law. It strikes a new balance between by making a determination as to where the public interest and individual rights, how to strike that balance. And that's the importance of invoking Parliament's invocation of Section 13.
And when you say Section 13 there, you mean of the Constitution? Of
the Constitution. So, my Lord, it might be the same subject matter, but similarities does not mean that the old provisions were simply reenacted, or else a saved law could never be changed. Parliament has, and if we, when I take you through the changes.
Well, I mean, a saved law could be changed.
Yes.
But it might be said that it's unusual for laws to be introduced dealing completely afresh with legal topics.
Indeed.
The law is developed and builds on what went before. But I think the point you're making is that in 1986, Parliament took control of the situation as a matter of public policy and legislated in the light of its view of public policy as it applied at that time.
Indeed.
And I think I'm right that the Section 13 of the Constitution was brought into operation in relation to the 1986 Act because of statements on the face of the legislation.
Yes, yes.
Can you just point us to those?
Certainly, my Lord. It's in the bundle of legislation, and you will find it at tab 7. Page 2442. Page 2442, and it says, and you will see an act to replace and repeal the laws of Trinidad and Tobago relating to sexual crimes, and you will see under that the declaration with respect to inconsistency with the Fundamental Rights Clause, and that it has to be supported by a special majority of a 3/5 majority in each House of Parliament. And you'll see that at 2443 at the top.
And is this right, that you're pointing to this in order to support your submission, that this was a new exercise of legislative authority by Parliament?
Indeed.
And you say, just so that I can understand, that we have to take that into account when we come back to construe Section 6.2?
Yes, I do. Indeed, my Lord.
We say that you were also making the point that the very fact that they use the Section 13 procedure must mean that they realised that it was not existing law, or just that they realised that it went further than the existing law?
I think it's a recognition by Parliament and a signal to the world at large that they intended to create a new law. And if it is indeed a new law that Parliament was enacting, Section 6 does not apply. And that will be the end of the case on the first point, as far as we're concerned. Because if Section 6 doesn't apply, we know that there is no dispute, really, as to the fact that it's not reasonably justifiable in a democratic society with respect for fundamental rights. So, my lords, if I may take you to page 1447 of the bundle, you will see at paragraphs 9.35 to 9.39, that is our written case, we have set out the extent of the revolutionary changes made by the Sexual Offences Act. And I'll just briefly take you through them. Of course, bestiality, firstly, at paragraph 935, 1447. Bestiality was removed from the definition and created a separate offence. It's noteworthy that that did not occur in England until 2003. Buggery was now expressly stated to refer to anal penetration between men and or between men and women. Even the respondent in their written submissions in the courts below accepted that this was a more nuanced approach and modern approach to defining the crime of buggery, while at the same time preserving the offence. Section 15 did not refer to attempted buggery nor assault with intent to commit buggery. To the extent that these offences would have been covered by the offence of indecent assault was now statutorily defined. The offence was extended to women when it previously applied only to assault by men on men.
Well, in the old 1925, it said committed either with mankind.
Yes.
I'd sort of thought that mankind includes women, but are you saying that the old offence was only men?
On indecent assault?
No, Section 60.
Oh, I see. No, I think I'll have to concede that on Section 60, the mankind has been interpreted. I think we conceded that your point includes women.
I think your point related to Section 62.
62, that's correct.
No, that's...
Yes, it does. That's correct. And then, we say, the offence was extended to women. Section 15 stated that a person under 16 years of age could not consent to indecent activity. Consent would therefore not be a defence in such cases. Section 15 provided for a harsher penalty in that the maximum sentence was 5 years imprisonment as opposed to 2 years. The sentence in Section 15 was later, of course, as we know, increased to 10 years. And we say Section 13 reflected a more modern approach to sentencing by providing a graded scale of penalties, including a lesser penalty for a person under 18. Buggery offences involving children were later repealed in the 2012 Act and replaced by offences in the Children's Act. It provided more severe penalties than in the OPA, namely 10 years for buggery between males as opposed to 5 years imprisonment, and that, of course, was later increased to 25 years. Section 16, you will see, of course, the Labouchere Amendment, which predated Section 16. We say Section 16 created the offence of serious indecency, which could be committed by women with women. There was no similar offence in Trinidad and Tobago previously. It created the offence of serious indecency for acts committed between heterosexual couples if engaging in such behavior in public. Again, there was no such similar offence in Trinidad previously. Section 16 related only to non-penetrative sexual activity, whereas previously there was an overlap between the activity captured by Sections 60 and 62. It restricted the offence of serious indecency to the use of genital organ excluding penetration, whereas the offence of gross indecency was much broader and included other acts classified as indecent. Provided for a higher maximum penalty of 5 years instead of 2, which was later increased to 10, and a range of penalties which depended on the age of the participants, although that was repealed in 2012. And what we say simply is that this was a complete reconceptualization and redesigning of the previous offences in light of a modern emerging Trinidad and Tobago society. It was both a broadening and restricting of the types of behavior captured by these offences, including the contemplation of female homosexuality for the very first time, and with a more up-to-date sentencing policy. It cannot be that this, on the ordinary use of the English language, could possibly fall within modifications. Modifications is not defined in the Constitution. And we say the significant alterations to the text, scope, application, and punishment of the offences was such that it really was, as it says, a replacement of the law. Now, so our submission is that by invoking Section 13, Parliament must be taken to have intended to use an escape route out of Section 6(2). It took a deliberate, conscious policy decision to invoke Section 13, which is a higher form of lawmaking power. And that power having been invoked, it is not a modification of the existing law. Can I take you to page 2796 of the bundle on this point? And this is the case of Suraj, the COVID-19 case.
I'm sorry, I missed the page reference.
It's 2796.
Thank you.
And it's the Suraj judgment at paragraph 92, page 2796. And the board this is the judgment in which the board resolved the issue of how to interpret Section 13 and the relationship with proportionality. Incidentally, Mr. Knox and I are on the same side. We appeared for the appellant in this matter. Paragraph 92, that the proportionality framework may be affected by the extent of the engagement of democratic institutions of the state is well attested by decisions in other jurisdictions. And they cite re-SC, which is a minor, and the judgment's been anonymized. In the context of the Constitution, where the Act has been passed using the supermajority procedure in Section 13, the democratic credentials of the measure are especially strong in the language used by my Lord Reed in SC. Accordingly, although the court has to make the ultimate judgment whether the proviso has been satisfied or not, it is obliged in doing so to give especially great weight to the judgment of Parliament regarding the importance of the public interest which is sought to be promoted by the measure in question. In the context of Section 13, it is clear that the intention is that the weight to be given to the judgment of Parliament regarding the importance of the public interest and how individual rights should be accommodated in relation to that is even greater than in relation to an ordinary proportionality assessment, because the Constitution itself provides that Parliament may override the ordinary application of rights in Section 4, where it judges the public interest, requires this, provided it faces up directly to the possibility that the measure may be inconsistent with 4 and 5 and uses the supermajority procedure. The proviso in Section 13 is a long-stop check against abuse of that power and cannot be taken merely to replicate the ordinary proportionality standard inherent in rights under Section 4. What the board, in effect, said in Suraj is that Section 13 amounts to a careful consideration, review and consideration by Parliament of the law, and the democratic credentials of the legislation are such that the court will have a lower level of intensity in terms of judicial review in dealing with such legislation. Now, in the context of Trinidad and Tobago, that is especially important because of the way the upper house is configured. The upper house is configured with 9 independent senators, so that you have to get the support of at least 4 independent senators to meet that 3/5 majority. So, in other words, the 3/5 majority in an emerging, fledgling, independent democratic state, that 3/5 majority was put there because you would either have to have an overwhelming electoral mandate or you will need cross-party support. And in any event, and that's in the lower house, but in any event, you will need to get support from the independent bench in the upper house, in the Senate. And that, we say, is significant. And that is why, when Parliament does not invoke its ordinary lawmaking power to pass a law with a simple majority, but it invokes Section 13, where it has to decide where the balance lies between the public interest and individual rights, that is a significant consideration by Parliament. And the law that it produces is a law that is a byproduct of the collective will and consciousness of Parliament, and it ought to be treated as such. It cannot be that it is a matter where you can use the constitutional anomaly and aberration of Section 6 to defeat the express will of Parliament in a situation where it invokes Section 13. That would be anti-democratic, and it will be inimical to and undermine the constitutional rights that are guaranteed by Sections 4 and 5. The whole point is, in the constitutional democracy that emerged in the post-colonial era, Parliament is the mechanism set up by the architecture of the Constitution, where you govern with the will and consent of the people through an electoral democracy. And to get a 3/5 majority, it's an overwhelming mandate from the people, and Parliament is meant to pass the laws in accordance if it invokes Section 13.
Well, we're going to come on to this. I mean, it follows from the points we've just been making that the wider the scope of Section 6, the less the scope for Parliament to give effect to its view of current policy by its ordinary procedures, by an ordinary majority vote. Now, that may have a bearing on how one should approach the interpretation of Section 6, which is really
of course. Yes, and my Lord, perhaps rightly so. I think the framers of the Constitution intended that if Parliament wanted to contract out, as it were, of that constitutional immunity, perhaps they should invoke a higher lawmaking power, as mentioned in Sections 13 and 54. And I see nothing wrong with that, because, I mean, what that means, in effect, is that if they do it by way of the ordinary lawmaking power, you have the snapback, the boomerang effect, where the old law, the default position of the old law revised. Parliament must be presumed to know the law. Parliament would know that if they use their ordinary lawmaking power, that law, to the extent that the extra derogation is deemed to be inconsistent with fundamental rights, you have a boomerang effect where you automatically go back to the default position. But they must know as well, and be taken to know, that if you invoke Section 13, that you are outside of that provision in Section 6. And I want to say this. Section 6, I described it as a constitutional anomaly and aberration. It is because when Parliament makes a law, it is very odd to have a provision in a constitution that can defeat the express will of Parliament. And that is what Section 6 does. If Parliament were to make a law, and change the saved law, Section 6 has an automatic default so that the old law, which is repealed, is automatically reinstated by operation of Section 6, notwithstanding the express will of the Parliament. And that, my Lord, because of it, we are a constitutional democracy, that supports a narrow interpretation of Section 6. We must, it is a rights-based approach to interpreting Section 6 consistent with the concept of a participatory democracy which is enshrined in the preamble and which gives rise to a parliament making laws to govern people with the consent of the people. And that is why the invocation of Section 13 is so important. Can I take you to page 1775 to make this point? This is the page 1775. It's the judgment of Justice of Appeal Corcoran in his dissent, with which we completely associate ourselves. At paragraph 307, he says, in passing this new law, there was a deliberate attempt to embrace modern constitutional principles by invoking Section 13 procedure of utilizing the supermajority. So, such a supermajority or certification by Section 13 is not necessary to validate an existing law. To do so will subject the existing law to the proportionality analysis contemplated by Section 13. The moment Parliament chose that route, it re-emphasized its intention and implanted the Section 13 proportionality analysis onto these offences. It is a clear signal, in my view, creating the new sexual offences and serious indecency, mindful of the wide import of the fundamental rights enshrined in Sections 4 and 5, a consideration which was never in the minds of the Legislative Council in 25 or 39. It is of no moment that the legislation seeks to treat with the same type of activity or sexual conduct as under the old law. That is inherently the exercise of modernizing laws, and inevitably to update an old law and to remove it altogether, one must still treat with how should the modern society view this type of sexual activity. In this case, there's a new offence of buggery and penalties and so forth. We've dealt with that. The structure of the legislation demonstrates that these are treated as much more serious offences. The severity of the penalties demonstrate the change in view of society to target and the mischief of upsurging criminal sexual behaviour and to update its disapproval of sexual intimacy. Finally, if resort to Hansard is made, the Attorney General piloted it. The purpose of the bill was to provide a comprehensive code to deal with sexual and related offences and to modernise the law to bring it up to date with moral and current thinking in society. It was a fresh consideration of the extent to which the criminal law should deal with sexual conduct, morality and public standard of decency, and was cognizant of modern moral values. It was legislation that was available for public comment, but was met with disappointing poor public participation. The trial judge was wrong to conclude it was not a reenactment, and therefore a Section 13 analysis required. This legislation went through the Law Reform Commission. It was put out for public comment, so that it really was, it went through the full, it enhances the democratic credentials of the legislation, as my Lord Reed said in the case of re-SC. It is not Parliament often resolves matters not by reference to by political compromise and different kind of dynamics in how it strikes how it identifies where the fulcrum to find constitutional equilibrium between the individual rights of citizens and, of course, the public interest would lie. Can I now move to...
Do we have the Law Commission report?
The Law Commission's report. I don't think it's in the bundle, but I think I've been trying to find it. I can't say that I have. I don't know if it's...
But I mean, isn't that material to your argument?
It is, my Lord, but I have to say, in the same way we couldn't locate some of the ordinances, unfortunately we've been having some difficulty in finding that report, and I apologise. But if the state can't find it, woe be it for Mr. Jones to find it. Can I then move to a point that radiates from the Section 13 analysis, and it is this.
Well, sorry, just before we move on from Section 13, I mean, in some ways, one can see that where the Section 13 procedure under the Constitution is invoked, Parliament is making itself even more accountable, if you like, to the democratic forces in the country, because it has to achieve a supermajority. But also, it might be said that it's making itself accountable to the Constitution because of the review procedure under Section 13.
Correct.
So it might be said that if one took a wide interpretation of Section 6.2, it tends to undermine the accountability of Parliament in both respects, both because, in the end, if Section 6.2 applies, you didn't need to invoke Section 13 at all and use the supermajority, and you're taken outside any form of accountability under Section 13 to the Constitution.
Well, my Lord, we say if it's a new law, the way I look at it is this: if it's a new law, the accountability is enhanced because you are subject to judicial review under Section 13.
Yes.
And we say that is the better form of constitutional accountability.
That's what I meant by accountability.
Well, my Lord, yes. Sorry. Yeah.
Yes.
So, my Lord, yes.
But couldn't the adoption of the Section 13 procedure could be prompted by two thoughts. First of all, this is entirely new law, not bearing in mind Section 6 at all. This is new law. We know it's incompatible. It derogates from people's rights. But we face up to that. We want to do that. We get a supermajority. But it could also be we need to adopt Section 13 procedure because even though this is existing law, we accept that it derogates further, and we don't want the existing law to be substituted by the operation of Section 6.2. Therefore, we are precluding that possibility also by using Section 13, because Section 13 is referred to in Section 6.2. So I'm not sure why you say that the adoption of the Section 13 supermajority process points to a thought that this must be new law rather than trying to leap over Section 6.2.
Well, I agree entirely. I mean, our primary submission is by invoking Section 13, you've taken yourself outside of Section 6.2. Section 6.2, I described it as one of two escape routes. So, my lady, I agree entirely. It is one of two escape routes identified by Section 6.2 itself. The other is Section 54. I mean, may I invite the board to just look at Section 6.2, which we'll find at page. Yeah, it's in the hard copy bundle we passed up, and it's at page 2321. 2321. Yeah, in the electronic bundle. And if you look at the construct of Section 6.2, there are four constituent parts. And if you read Section 6.2 without the words subject to Sections 13 and 54, if you read it without that and just put in parentheses and read it without that, what you get is a situation where when the enactment repeals and re-enacts with modifications an existing law that there's an extra derogation from the rights, the provisions of the existing law shall be substituted for the extra derogation. That is consistent with the position taken in 6.1. All that happens if you leave out subject to Sections 13 and 54 is you have the snapback and the automatic reversion to the default position of the old law. That would be consistent with 6.1. However, we then have to ask ourselves, if we reread it and we insert the words subject to Sections 13 and 54, what then was the import of saying subject to Sections 13 and 54? And my submission in that regard is that as a matter of statutory construction, it provides these two escape routes. It makes Section 6.2 expressly subject to these two higher forms of lawmaking power provided for in the Constitution with the use of supermajorities. And therefore, if Parliament invokes those either of those two supermajority provisions, it must be taken to have that the Constitution itself intended that Section 6.2 will not apply, because Section 6.2 is made expressly subject to Sections 54 and Sections 13. So we say Section 6.2 simply makes clear the fact that the automatic substitution of the former law is merely the constitutional default position where Parliament has acted in the exercise of its ordinary powers. That's all it is. Can I then move on to...
Can I just...
yes, my lord.
I mean, it seems to me there are two separate points that you've made on this part of the argument. One is that the fact that they've gone down Section 13 indicates that Section 6 is not applicable.
Yes.
But the second point, which in a sense I don't think you've amplified, is that in any event, where you've got this relationship between a Section 6 and a Section 13, you would want to construe Section 6 narrowly.
Indeed.
Because otherwise it would undermine the constitutional way in which it's been set up. Now, I think there are authorities on that in almost all constitutions of this kind with these sort of provisions.
Yes.
Isn't that right?
Yes, indeed. Any provision, any doubt and ambiguity has to be resolved in favour of the will of Parliament and the fundamental rights. And any provision that has any ambiguity and so on has to be construed again in favour of the express will of Parliament and the fundamental rights. And we said that the submission we make is consistent with those cardinal constitutional principles and principles of statutory interpretation. So we say, even if we are wrong on all of that, the combined effect of all of the clues that we have and which are aids to construction, the language of reform that is used, the invocation of the special majority, the content itself of the act, with a total overhaul. We say all of these things combined, when one takes a panoramic constitutional overview, it has to be a new law. It cannot be a mere modification. Now, my learned friend's position on this is they say...
sorry, are you moving on now from Section 6, or are you going to come back to that later? I just had a question on...
Sure, my lord, I'm happy to deal with it now.
So, Section 6.3 defines alters, which is relevant to Section 6.1c.
Yes.
And it says it includes, so it's not necessarily exhaustive, repealing that law and re-enacting it with modifications. And one sees that terminology also marries up with Section 6.2, repeal and re-enact with modifications.
Yes.
But then there are two other categories, all making different provisions in place of it, or modifying it.
Yes.
And I just wondered whether the fact that a contrast seems to be drawn within that provision between repealing and re-enacting with modifications as opposed to making different provisions and as opposed to modifying it, again tends to suggest that repeal and re-enactment with modification is intended to be a very narrow concept.
Indeed.
So it's not that any modification of the provision, which would fall within the third of those,
correct,
qualifies as repeal and re-enactment with modification.
Yes, my lord.
One's looking at some sort of different idea.
Yeah, my lord, that is our position, my lord. Or else you will constitutionalize the immunity that is given in Section 6 for time immemorial. Any amendment, any replacement, any repeal will be deemed to be an alteration that's captured by Section 6, and you can't escape the tentacles of the saved law anymore. I mean, so that where does one draw demarcate the constitutional boundaries for Section 6? And that is why we say it must be drawn tightly and narrowly to give effect to these wider philosophical constitutional principles.
Well, just drawing the points that have been made in the last few minutes together, you've agreed with Lord Burrows that there is a considerable body of authority to the effect that the exception for existing law in a constitution of this kind should be construed narrowly. That's the first point.
Yes.
The second point is that you've accepted in your discussion with my Lord Sales that the legislation has a definition of the word alters, which includes, on the one hand, repealing and re-enacting an existing law with modifications, and on the other hand, making different provisions in place of it or modifying it.
Yes.
Okay? So the first of those categories is obviously narrower than a broader concept of alteration.
Yes.
Okay? Now, the definition of alters is only relevant to 6.1c.
Indeed.
Which is not what we're concerned with.
No.
But the majority in the Court of Appeal in this case fastened on the words making different provisions in place of it or modifying it.
Correct.
In that definition.
Yeah, and we say that's an error of law because it conflated the two distinct concepts where the drafting of the sections was clear and deliberate. Section 6.1 uses the concept of alteration twice, in section 6.1b and in section 6.1c. But the draftsman in section 6.2 deliberately eschewed using that particular terminology. And one must therefore take it that presumptively they intended something completely different for 6.2.
Yeah. I mean, I wonder whether the point on section 6.3 might be expanded slightly as well in this way. I mean, the boundaries between repealing a law and re-enacting it with modifications, or making different provisions, or modifying it, would obviously, if you're looking at things purely substantively, be quite difficult to draw between those three categories. But I wonder whether the fact that the legislator has used those three categories and obviously thinks that they mean something different, it means that if Parliament wants to make use, if you like, of the authority that's given to it in section 6.2, and it is giving legislative authority, it's incumbent on Parliament to make it clear that the category that it's intending to invoke is that of repealing the law and re-enacting it with the modifications, as opposed just to modifying it in a more general sense.
Yes, indeed, and we said that is precisely what Parliament did here. It made clear its intention from the onset in the long title, and that was not something that should have been glossed over by the Court of Appeal.
So and what I'm putting to you, and obviously Mr. Knox, that's a point Mr. Knox will be invited to deal with, is that section 6.2 is giving a power to Parliament to do something, but it might be said that Parliament has to make it clear that it is indeed seeking to use that power if it's to have the benefit of section 6.2.
Yes, I accept that, my lord. And in the event Parliament erred, one will still have to examine the substance of the legislation to see whether it can be deemed a modification or, in any event, a new law. And we say, in any event, the substance, the procedure used, the content, the procedure, the content, and the long titles, when taken either separately or together, it is clear that what they were doing is enacting a new law outwith the confines of section 6.2.
One of the points that's made is that the section 6 has to apply not just to repealing and re-enacting old legislation, but existing law covers not just enactments, but the common law as well.
Indeed.
So that I think what's said is that 6.1c would arise if, for example, an area of the common law, say libel or something, was then put into legislation. The legislation was a codification of the existing common law and didn't go further than the existing common law. That would be an alteration of the existing law. That would be, I suppose, making different provision in place of it.
Indeed, Milady.
But is 6.2 really limited to
extra derogation on the fundamental right?
No, I was about to say, is it really limited to repealing legislation so that it's got a narrower scope because it's not dealing with enactments which codify common law?
Yes. I mean, it does say repeals and re-enacts with modifications.
Yeah, and existing law. So existing law may have a narrower meaning there.
Yes. Because the concept of repeal wouldn't really be, wouldn't sit nicely with the common law.
Yeah.
So,
or reenactment.
Or reenactment. No. So our interpretation is yes, that applies to a repeal of an act or an ordinance.
So if you decided, or if the Parliament decided to bring in legislation dealing with an area that had previously been dealt with in the common law, but actually made the law derogate further than the common law had, then that would not be in 6.1c, nor would it be in 6.2.
No.
It would just be new law.
New law.
And it's subject to the Constitution, and if it's passed by a supermajority, it's subject to the reasonable justification proviso.
Yes. Well, it'll be subject to the reasonable justification, whether it's regardless of whether it's passed with a special, simple or special majority. If it's a new law. Yes, but
you would have the surrounding proportionality.
Indeed. Yeah, the intensity of the review is different. I mean, the difficulty I have with the respondents' position in this matter is that they seem, the upshot of it really is that constitutional immunity attaches to the subject matter, or the topic rather than the law itself, because it assumes that constitutional immunity is capable of traveling indefinitely from one statute to another, despite the invocation of Section 13 for the first time after its Parliament intervenes. I mean, many reforms cover the same ground as the previous law, but because they target same or similar problems, but in new ways. But that doesn't mean it's not a complete reconsideration by Parliament of the problems that are affecting the society by reference to contemporary values. And that's why we say the limitations on fundamental rights should be given a strict and narrow interpretation. And we advocate that Section 6 ought to be given a narrow interpretation. So this law introduced a comprehensive new statutory code. It created new offences. It redefined existing offences. It altered penalties. It introduced entirely new concepts. It reorganized the statutory structure. It legislated afresh after a complete reconsideration of the criminal law governing sexual offences. And that could hardly be equated with a situation where Parliament was simply amending the old law or modifying it within the meaning of Section 6, as far as the appellant is concerned. Now, the word modifications is not defined. And we say that might very well be a fact-sensitive issue depending on the particular case and the particular the legislative context and history and all of the factors that we've identified. It's not simply about the number of words changed, although the extent of the difference between the old and the new will obviously be relevant. nor is it simply a question as broad as whether the new law contains the substance of the old. But there are some factors that are readily apparent from this case that we say would be constitutional clues that will guide this process. Firstly, the wording and structure of the law, and any indication given by Parliament in the Act's title, explanatory notes, or otherwise. The significance of the changes made in the context of the law as a whole. The mechanism by which the new law was enacted, for example, whether the new law was part of a wider package of reform or whether there was a more discrete change made to one or a limited number of provisions, where the whole Act was not before Parliament for consideration. And finally, and we say crucially, how easy or not would it be to apply Section 6.2 to restore the law to its old state would be a good indicator as to whether the new law was a reenactment with modifications of the old. Now, I make that point because when one looks at the way the Court of Appeal, in terms of the remedy granted, it's tantamount to impermissible judicial rewriting of the legislation. They had to construct a legal Frankenstein in order to give meaning to their judgment, because you could not have the snapback, the boomerang to the default position simply wasn't, it was impossible to reconcile the two positions. And there can be no doubt here that the amendments were so substantial, there was no possibility of simply saying, well, we revert to the default position on the new law. So the difference between us is that the respondents seek to give modifications.
So can I just be
yes, please, my Lord.
Clear on that point? So if we look at your handout
yes.
From this morning,
yes, please, my Lord.
And we're looking at the
last
the page with the most track changes on it.
Yes, yes.
You're saying that if you turn back the previous page, which would be the old law,
yes,
that in a sense is what one ought to be doing, but the Court of Appeal didn't do that.
No.
They've had to sort of produce a mid-position.
Yes, it was impermissible judicial legislating. Because you see, the law was so completely revamped and changed. This was not a simple amendment to the law. This was not an amendment where you change the term of imprisonment from 5 to 10 years, so that if the extra derogation of 10 years is unconstitutional, you snap back to 5.
Well, I think that's a difficult point, whether increasing a sentence is a modification or an alteration. I mean, it could be said that by increasing the sentence, you are reassessing, or that is the result of a reassessment by Parliament of the seriousness with which society views this particular crime.
This is true, my lady. I see the force in that. But the submission I make is simply that...
I mean, I think if it was just that, instead of rather curiously including attempt to commit buggery and indecent assault in a single section, as had been in 61.
Yes, that's a good example.
Just been split out to make it clearer.
Yeah.
That might be a modification.
Yes, I mean, we can consider many permutations, but the point is, the reverting to the existing law should be that if that's the automatic effect of Section 6, that should be very clearly possible. Or else you run into this problem here where you have a hodgepodge of judicial rewriting of the legislation, which we say is impermissible in its own right. And we say the error lies in the fact that they are giving modification the widest possible meaning when it ought properly to be given the narrow and much strict and narrower interpretation. Or else the wider berth given to the concept of modification will have the effect of meaning every legislative amendment or reconsideration becomes merely another modification. Then each such modification successively in time will inherit the constitutional immunity. So there's an umbilical cord that connects them all. And every later enactment will be considered part of the existing law, and that process will continue indefinitely. I mean, thereby stultifying Parliament's will and ability to actually intervene as it were. So that brings me to my final point. Okay, thank you. My lords, the last point really I want to treat with is, my learned friend says that, look, in any event, although they don't cross appeal, he says that they want to revisit the reasonable justification test because they want to argue that in 1986 it would have been considered reasonably justifiable to have these provisions that obviously derogate the fundamental rights of Jason Jones and others.
In 1986?
86, yeah. Yep. That is what I understand their position to be. They adopt a slightly different approach from the Court of Appeal as to how Section 13 should be interpreted. The Court of Appeal did not distinguish between the additional derogations of the rights in Sections 13 and 16 and the sections as a whole, and found that neither Section 13 nor 16 could be said to be reasonably justifiable. The respondent's position seems to be this. It does not challenge the Court of Appeal's reasoning that further derogations from rights were not reasonably justifiable. It does, however, assert that if Sections 13 and 16, aside from the additional derogations, do not fall within Section 6.2, the appellant has not shown that they aren't reasonably justifiable under Section 13 of the Constitution. That is how I understand their submission, and their point is that the relevant point in time to assess the balance between individual rights and public interest is 1986 when the law was passed.
So do you think that they're saying that the reasonably justifiable test to be applied under 13 is different if you're applying it within the context of Section 6.2 than if you're applying it to the law, having decided Section 6.2 has no application, this is new law, it still has to be reasonably justified? Is that what you're...
Melody, that's the sense I get from it. I mean, my brilliant friend will certainly elucidate on those submissions, but the difficulty we have is this. I mean, it's one thing for Parliament to legislate within a particular social context. It's quite another to suggest that constitutional justification becomes permanently frozen at the date of the enactment. Neither proposition follows from the other, and indeed constitutional rights would become progressively stronger whilst the constitutional limitations remain permanently fixed. And that's, we say, is the error in their submissions.
I mean, yes, I'm looking at Section 13 of the Constitution on page 2324. It's talking about the effect of the law unless the act is shown not to be reasonably justifiable in a society that has a proper respect for the rights and freedoms of the individual. I mean, I think it might be said that's not time limited. That's looking at the effect at any particular point in time. And secondly, it might be said that the analysis in Suraj, which says that that is a manifestation of the proportionality standard, and the usual position is that one tests the proportionality of a law at the time that it's being applied, also leads to the conclusion that you look at the reasonable justification of enforcement of this law in the society as it stands now.
Indeed, my lord. The whole
is that your position?
That is our position. The concept of proportionality, which is the litmus test and the constitutional barometer by which we measure the infringement on rights, is rooted in the concept of what is reasonably justifiable at the current point in time. Mr. Jason Jones is not saying my rights were infringed in 1986, full stop. He's saying it's a continuing violation of my rights. And therefore, the proportionality test is one that obviously has to be applied, as it did in Suraj. In Suraj, the board dismissed the appeal because what would ordinarily be an unjustified interference with fundamental rights, i.e. restrictions on association and all of that, was justified because we were in the midst of a pandemic. So we judged the proportionality of the regulations by reference to what was the current prevailing situation.
Well, I mean, I need to remind myself about Siraj, but I think that there wasn't a big gap in time between the passage of the legislation, which was designed to address the COVID pandemic, and the application of that law.
You may recall that it was subsidiary law, it was the regulations, but the parent act was the public health ordinance, which was pretty old. So the regulations made thereunder was in direct response to the pandemic. But the point is, the approach taken by the board in assessing the reasonable justification was by reference to what was the current situation, and not what the situation was in 19-whatever when the public health ordinance was passed.
All right, thank you.
And isn't this just a manifestation of the always speaking idea?
Indeed, my lord. Indeed.
Or the living tree. Perhaps living tree approach.
Yes, it's a living tree. It's the always speaking. You know, it's,
and I'm just thinking of examples. But you know, there's UK English authority on divorce provisions that talk about reasonable behaviour, for example, and that is judged according to the moral and social conditions today, not when the Act was actually passed. And I would have thought that reasonably justifiable in the society, you would, prima facie anyway, think of that as applicable today, not at the time the Act was passed.
That is indeed our position with respect to the argument that the reasonable justification test must be time-capped and frozen by reference to when the Act was passed. My Lord, I've asked my learned friend... so, my Lord, the other point which my learned friend, my learned junior...
Just if you're moving on from that, yes. Presumably you're saying even if one does test it, the position in 1986, it still
fails. It still fails.
Still fails.
In any event. Yes, my Lord, I'm grateful. Because we say that whether it's 1986 or now, the fact of the matter is there is simply no reasonable justification in a democratic society with respect for fundamental rights for this to happen. I mean, the scientific evidence in 1986 as compared to now, as it relates to homosexuality, hasn't changed. But the fact is, the scientific evidence has long suggested, since the Alfred Kinsey Institute for Sexual Research on Humans occurred in the early 80s and the late 70s, all of the research showed that sexual orientation was generally regarded as congenital or established in early biological development, although it wasn't hereditary in the sense that it could be transmitted from a parent to a child by a single identifiable gene. But the point is, that's been the state of our understanding of human sexuality for quite some time.
Yes, but it might be said that there's been a significant change in social and moral approaches to homosexuality over that period of time, wouldn't you say?
Oh yes, my Lord, it's constantly evolving. There's been a change in society's approach to interracial marriages. The way the Jewish community has been reintegrated in the post-World War II era, and many different things. So societies, but what has the catalyst for all of these things in terms of what prompts that evolution, that social evolution in thinking, is always the law. It's always the law, and that is why whether I shudder to think if this was slavery, what would happen? It would be a saved law. I mean, the point is the law, as my Lord Reid has said in many judgments, the law is meant to protect the vulnerable and the minority, and all we ask for in this matter really is precisely that, to be given the constitutional protection and shelter of the right to equality of treatment before the law and in the eyes of the law. I mean, history has taught us repeatedly that far too often, reflected in the prejudices of human beings, things have occurred that demonstrate man's own inhumanity to man. I mean, slavery was once lawful. Interracial marriages was once condemned as unnatural and immoral. Women was once denied equal rights because society believed that that was to be the natural order of things, that they were good for child-rearing, childbearing, and being good homemakers, full stop. I mean, ultimately, we need to ask ourselves the hard legal conscience question of who are we to volunteer that gay people should starve because we don't like the meat that they eat? Constitutional rights exist precisely because majorities are not always right. They ensure that the dignity and equality of every citizen are not left to the changing tides of public opinion. And Jason Jones asks for no special privilege. He asks only that the Constitution protects him as it does every other citizen. And we ask that the board give him the shelter of that constitutional protection. I'll pass over to my learned friend, Ms. Amanda Cliff Matthews, to deal with the other point about the subsequent amendments and how it should be treated. Much obliged.
Yes, Ms. Cliff Matthews.
This is a further argument as to why Section 13 and Section 16 of the Sexual Offences Act do not come within Section 6.2. And if I could take you back to the document that you've been handed and just show you the additional legislation. So moving on from the Sexual Offences Act, which Mr. Ramlogan took you to, with all the changes. So if you turn over, you get to another amendment. There have been several amendments to the Sexual Offences Act, but these two that I'm going to highlight affect Section 13 and Section 16.
You're taking us first to the 2000 amendment.
That's exactly right, my lord, yes. So you can see there at a glance that there was a change in the penalty for buggery committed by an adult on an adult from 10 years to 25 years. In 16.1, there is a change in the penalty for a second offence, but that relates to minors. But if you turn over, what you come to is the Children Act, which was enacted in 2012. Now, one of the purposes of the Act was to bring all offences involving children under the Children Act, both against and committed by. And you can see that there were changes again to 13.1 and 16.1. If I could just ask you to go to the actual amendment itself, it's at 1909. So these are the changes to the Sexual Offences Act. If you go to D, you can see it says, in Section 13, by deleting subsection 1 and substituting the following subsection, a person who commits the offence of buggery is liable on conviction to imprisonment for 25 years. And similarly, the same in Section 16, and there are some additional amendments to Section 16.2. So both provisions were deleted in 2012 and substituted with something else. So if we go back to the Constitution, to Section 6 on 2321.
Yes.
Well, I think we.
I'm sorry. I just wanted to follow this, and it looks as though there was also an amendment to disapply 16.1.
Yes, sorry, I should have mentioned that, my lord. Yes, disapply to children. That was.
Right, and I take it that yes. So Section 20, subsections 1, 2, and 3, I presume provide a relevant definition of children. Do they?
Yes, indeed. So those are offences committed by children, and basically it's a similar sort of offence. It's sort of sexual activity with the child, but there are differences in the age of the person who commits that offence. So I think one deals with persons, under 16. One deals with persons where there's only 3 years difference, or so forth. So it's sort of a nuanced approach, and that's what that refers to. So that's excluded from the serious indecency.
And that's the definition that the Court of Appeal adopted in its order when it generally disapplied 16.1 and 16.2 in respect of consenting adults, but ordered they should continue to apply to persons to whom the definition of children applied. That's
Yes.
at page 175.
So, yes, my lord. So, I mean, I have to say, I find this order very difficult to follow.
Well, you're not alone in that.
Well, in fact, that was going to provoke me into asking for some assistance. We've had the helpful handout that you've given us with the redlining and the crossing out. Would it be possible to produce an additional page with the effect that is produced by the Court of Appeal's order, so that we can get a graphic understanding of what changes that involved? And
so the Children Act included some separate offences within that Act rather than by amendment to the Sexual Offences Act?
Well, it just deleted certain sections of the Sexual Offences Act that included reference to offences against children. So buggery against a minor, for example.
Yeah, but that was presumably then replaced by something in the Children Act.
It was in the Children Act, and it's still an offence
right.
with the same
but
punishment.
Was there anything in those provisions, which I don't think are included in the helpful... So what there is now, instead of the 1925 Act, if one can go back to that, is a mixture of some provisions that are still in the Sexual Offences Act, some provisions that are now in the Children Act.
That's absolutely right, my lady.
But the Court of Appeal wasn't called upon to alter anything in the Children Act offence.
And I suspect that is because, I mean, firstly, the challenge was 213(1) of the Sexual Offences Act, as it now stands, which doesn't have any reference to it. And secondly, because I suspect, because of obviously the need to protect minors, that would have a totally different assessment in terms of what was reasonably justifiable and so forth. So it wouldn't necessarily it wouldn't necessarily be a derogation of rights.
Yeah, and am I right in assuming that the only legislation that was passed with a special majority was the 1986 Act?
No, my lord. In fact, it's not. I don't know why it's not, but it's not included here. Both the 2000 amendment and the 2012 Children Act were passed by the under Section 13. So the same would apply. There would still have to be the appellant would still need to prove that there was no reasonable justification for them.
So do we have the full text of...
Well, yes, and I think we should supply that, my lord. Unfortunately, we don't. But
we have
I have included in comparison.
Well, we do have the
in our
Children
case.
Act, and it begins on 1834, and we can see that it was it's enacted under reference to Section 13 of the Constitution.
Perhaps I can take you to 1460. So this is a schedule of the Offences Against the Person Act, the Sexual Offences Act, and then how it currently stands. And so you can see 13.1 is what was inserted by the Children Act. Section 2 is what remains of the 1986 Act, and that's the definition, obviously, of buggery. And it goes down to Section 16.1. That also sets out the offence, and that's what the Children Act inserted. And then there are some leftover provisions from the 1986 Act in subsection 2, but they are the exceptions to the offence. And then you have 3, which is the definition of serious indecency.
Now, I found I've found the preamble to the Children Act, and it clearly was made under Section 13 of the Constitution. But the 2000 Act, it appears on page 2458, and it's not apparent that it was passed with a majority.
I mean, I may be wrong, my lord, but from my recollection, it was.
Oh,
I don't know if...
That was my recollection. But
yes, you were the same. So, could you give me the number again, my lord? Would you mind?
2458.
Yes, I see what you're saying.
Okay.
Yes, it isn't apparent from that. You're absolutely right. I mean, I may be wrong, and maybe we could check that for you.
Yeah.
We'll do that to see whether it was.
Can we take it that either generally or always, when Section 13 is resorted to, that's always set out in the preamble?
Sorry, my lord?
Can we take it that when the Section 13 process is being resorted to, that is always set out in the preamble?
Yes, that's absolutely right. It's a requirement of Section 13.
The absence of
which just isn't. So that's, yes.
It's not just an
I just want to check that that is a full copy of the actual Act. As originally passed, exactly, because sometimes it's omitted when you have a reprint of it.
Yeah.
Right.
So if I could take you back to the Constitution at 2321. Now, what's being said is that the Section 13 and Section 16 of the Sexual Offences Act fall within Section 6.2. They don't fall within Section 6.1 because of the further derogations, and it would seem that Section 6.1 and 6.2 are actually mutually exclusive.
Yeah.
So Section 6.2 is what we're looking at. But if you go down to the definition of existing law, in 6.3, it says, existing law means a law that had effect as part of the law of Trinidad and Tobago immediately before the commencement of the Constitution, and includes any enactment referred to in subsection 1. What it doesn't include is an enactment that falls within subsection 2. So even if the Sexual Offences Act fell within Section 6.2, these later amendments do not, because they are not repealing and re-enacting with modifications an existing law.
So you're saying you only get one shot at it?
Exactly, my lord.
Effectively,
you get one shot.
Sort of incremental.
Absolutely, my lord. So you get it snaps back once, and then that's it. And that would make sense, obviously, because these are aberrations in the sense they are violations of rights that would otherwise be unconstitutional were it not for Section 6. So that's a very simple point that we make, and if that's correct, and subject to what we find out about the 2000 legislation, in fact, the only questions that need to be asked as far as Section 13.1 and Section 16.1, which are the subsections that actually specify the offence and the penalty, is whether they are reasonably justifiable under Section 13.
Well, I'm just thinking aloud, but it occurs to me to ask in the light of your submission a moment ago, what about the 1979 and what about the 1979
yes, good
Act
question.
and the 1980 consolidation?
Yes, good question. I was intending to take you through that, but then my learned friend did, and I thought I didn't want to waste the court's time by going through.
Because
let me go back.
The existing law, as it stood in 1976, is not was not the law as it stood in 1986.
Yes, absolutely. So if we go back to this sort of snapshot document that shows the track changes, we have on the first page we have the statute as enacted. Then on the second page we have the 1940 revision, and that's the one that was in force at the time of the Constitution being introduced. then the next thing we have is an act in 1979, and you can see there that what was the legislator did was to insert a subsection 2 to subsection 60. And that was, it basically extracted the offence against minors and put a much higher penalty for that offence. But section 60 is left unchanged. And it is section 61, which is said by the respondent to have been repealed and re-enacted as section 13(1). So from our perspective, even if the Sexual Offences Act did fall into section 6(2), there was no derogation, additional derogation of rights to 13, or what would be 13(1), in the 1979 Act. And nor, if you turn over the page, the 1980 Act, because that was a revision and it was just a sort of tidying up and removing, changing some of the language to update it. So the first time you get to a derogation is, a further derogation is in 1986.
Yes.
And so our short point is, my Lord, that if you are giving a strict and narrow interpretation to the savings clause, which one should, and to section 6(2), I mean, even on the face of it, you can see it excludes section 13(1) and section 16(1). They were not enacted in 1986, they were enacted in 2012. And they deleted and substituted a provision, but what they deleted was not an existing law.
Sorry, could you say that again? So, what was... Could you just say what you just said again?
So, looking at section 6(2), if you just read the first part of it and putting aside the modifications for the moment, the key point here is, to fall within section 6(2), it has to be an enactment that repeals and re-enacts with modifications an existing law. When you go to the definition of existing law, the Sexual Offences Act is not existing law. It doesn't fall in that definition, because that only includes enactments in section 6(1).
Yeah.
It doesn't include enactments in section 6(2). So those subsequent changes made by the Amendment Act and the Children Act, they were not amending an existing law, and that's, assuming that is a repeal and reenactment.
And the essence of your point, as I understand it, is that there's nothing in Section 6 or anywhere else that requires you to treat a post-constitutional repeal and reenactment that does fall within Section 6(1) or Section 6(2) as therefore being a kind of deemed existing law. It's new law.
It's new, yes, my Lord.
But isn't invalidated.
Yes, that's right, my Lord. And, I mean, I would try to find an example of this in the case law, and I haven't really been able to, but the closest I could find was the case of Watson, which I don't need to take you to, but the relevant paragraph starts at 3106. And effectively what happened there was the mandatory death penalty was in force in Jamaica before the introduction of the Constitution. An amendment was made by Parliament which restricted exposure to the death penalty to certain classes of cases. Now that was challenged, the mandatory death penalty was then challenged, and it came up to the board. And the Attorney General said, but it's just reenacting what we had before. The death penalty has always been a feature of the legislation in Jamaica, and there's no further derogation. In fact, it's actually a better position for fundamental rights because the category of people has narrowed who might be exposed to it. So what the Attorney General was saying is that you could transfer the protection from that law, that existing law, onto the amendment. And that was rejected by the board. And the simple reasoning of the board was, no, what you have to do is look very carefully at the wording of the existing clause applying a strict and narrow interpretation. And that's said at 3107. And we have a similar situation here.
Sorry, which paragraph are you referring to there?
Yeah, so if we go to paragraph 42, and if we go down for the 6 lines to guidance, it says, guidance as to how this issue should be approached is not to be found in any presumption as to whether the law was in force immediately before the appointed day secured fundamental rights, because that was what was being argued. They were referring to the case of Nasrallah. It is to be found in the principle of interpretation, which is now universally recognised and needs no citation of authority, that full recognition and effect must be given to fundamental rights. And if you go down, say, another 6 lines, it says, I think it's 5 lines, this means that careful attention must be paid to the precise meaning of the words used in section 26.9, which is the savings clause relying upon. And in this case, I mean, it's a different constitution. The amendments did not fall within that constitutional provision. So what I suppose we're saying is it's not the derogation that's saved, it is the statute that is saved.
Now, can I just be clear about the history here? We have the law as it stood in 1976. That's effectively the 1925 legislation as amended in 1939 and 1940.
Yes, that's right.
Then we have an amendment in 1979 which inserted subsection 2 of section 60.
That's absolutely right, yes.
But section 60, subsection 1, remained existing law.
It did, exactly.
Now,
and then
what happened in 1980?
In 1980, well, then there was a revision. The laws were tidied up as a whole. And you can see from section 61C of the Constitution that any enactment that alters an existing law but does not derogate from fundamental rights, in this chapter in a manner in which, or to an extent that the existing law did not previously derogate, is saved. And so this is what that did. It did make some changes, but the savings provision in Trinidad and Tobago is wide enough to include a situation like that. So this would have become the existing law.
So this because it falls within 6.1b or
C?
C.
And that means that qualifies as existing law for the purposes of section 6.2 when we come on later.
Yes, exactly. And so the Sexual Offences Act amended actually this Act, the 1980 revision.
So it's the final words of the definition of existing law, that it includes any enactment referred to in subsection 1.
That's right.
And you would say that that the 1980 revision was such an enactment.
Yes, indeed.
Yeah, I follow. Thank you.
That was all I proposed to say on this issue, my lords, my lady, unless there is anything else I can help you with.
No, thank you very much indeed. Oh, I'm sorry.
Are you going to deal with the argument that's made by the interveners to the effect that relying on Article 4 of the 1962 Order in Council? I mean, I'm not sure it's a good point, but...
No, we are not, my lady. We don't support that argument.
Okay.
Thank you.
That is the case for the appellant, my lords.
Thank you very much. Yes, Mr. Knox.
My lords, my lady, I'm going to start with the savings clause point. And you'll have seen that our submission is this. The 1986 Sexual Offences Act was, quote, an enactment which repeals and re-enacts with modifications. Those are the relevant words. Sections 59 and 61, as they were then numbered, of the Offences Against the Person Act, or revised Offences Against the Person Act. Section 35(1) and the first schedule of the Sexual Offences Act 1986 effected the repeals, and sections 13 and 16 of the Act affected the re-enactments with modifications, the all-important word modification. And therefore, we say the Court of Appeal correctly held that both sections 13 of the 1986 Act and section 16 of the 1986 Act were saved from challenge by section 6(2) of the Constitution, save insofar as the modifications derogated further from the fundamental rights and freedoms than the old section 59 and 61. Secondly, we say the later statutory amendments, to which Ms. Cliff Matthews has taken you to, which in essence altered, increased the penalties, made some alterations to section 16, did not deprive the Act passed in 1986 of the protection from challenge. The only effect, the only relevant effect of those later amendments is that to the extent they increase the penalties, then we accept they too must fall, and you revert back to the position in the old section 59 and old section 61. I propose, first of all, as you will see from our case, to say something about the 1962 Constitution, because it is our submission that Section 6 is actually a very deliberate and conscious attempt, we would say successful attempt, to firm up on the savings law clause and to get round problems which had come into existence in the interim period between 1962 and 1979. And it is our submission that one must give, first of all, Section 6 a natural construction and not a strained construction. And that on a natural construction, what you have here is a repeal and with modifications, and a reenactment with modifications. And neither of the other two categories set out in Section 6, which is A, modification on its own, or putting in place different provisions, we say they do not cover the situation. And I submit it would be artificial to say, when you've got a clearly traceable old provision and a new provision, to say that the new provision is not actually a reenactment with modifications. And that's the essence of our position.
So you're not supporting the reasoning of the majority in the Court of Appeal insofar as it relied on the words making different provisions in place of it or modifying?
No, my Lord, that is right. I mean, they're all important. The starting, the most important section in one sense is section 6(3), which gives a definition of alters, which then gives you the three types of way you can alter, one of which is repeal and reenact. You ask yourself, what does repeal and reenact mean? You go to section 6(2), because that's where it's really important. And they're all important, if I can just anticipate.
Why don't you ask it in the context of section 6(3)?
Well, you ask
because section 6(3) refers to three different things and obviously treats them as different.
Yes.
And how does, for example, one tell whether one's dealing with a case of repealing a law and reenacting it with modifications or simply modifying it?
Because a mere modification would be, let us say you have the law of burglary, for which, let us say, for the sake of example, there's a 10-year sentence. If you then passed an act which said the minimum term for burglary will be 5 years, you're not reenacting, you're not repealing anything, you're simply modifying the law of burglary. So modify refers to cases where there's no repeal in reenactment as such. Modify, and I respectfully submit this must be right, modify simply means I make an alteration to an existing law without actually repealing it at all. That's modify. I'm going ahead.
Well, all right. What about making different provisions in place of it?
Well, my Lord,
this is you obviously do have to repeal.
Well, my Lord, query. Of course, this is, I fully accept, this is where the battle is, if you like. First of all, I say, actually, no. Law covers common law. And so one obvious example of where you might talk naturally about making different provisions in place of the law, i.e. the common law, would be where there's no repeal of anything as such. This is simply dealing with the case where the common law is being changed. The other area where you might talk about...
changed by legislation.
By legislation. The other area where you could reasonably talk about making different provisions in place of the previous law would be, for instance, if you had wholesale alteration to the law of homicide. And it would be very difficult to trace the old to the new provision. But the essence of my submission is this. If you can reasonably trace the old to the new, that is a repeal and a re-enactment. And, my Lord, I'm jumping ahead, but the reason you can tell that must be right is because Section 6.2 requires the court, quote, to substitute the old with the new if the new goes too far. So what you're looking at when you're talking about repeal and re-enact with modifications is where you can see that one provision in the old Act is being now re-enacted in the new Act, but with modifications, and you can see that the two are obviously linked together. One is a replacement, or one is a re-enactment of the other with modifications. But that is how we say Section 6 works. You do have the three alternatives. They are different, but modifications is simply where there's no repeal, you just, as it were, add something to the law of burglary. Repeal and re-enact is where there's a specific repeal of a specific statute and re-enactment of an identifiable section. And I can't remember the phrasing now, replace or so make different provisions in place. That covers, for instance, the case of the common law, where the common law is being altered, or where you have, let's say, a major change in the law where you simply cannot realistically trace an old to a new provision. And that, we say, is an entirely rational scheme.
Cannot
trace.
You say that is included in making different provision in place of it.
Yes, if I'm making different provisions in place, then that presupposes that I'm not able to trace one provision to the other. But the essence of repeal and re-enact is you can identify the old.
Does that mean that you can never have a piece of legislation, unless it's dealing with digital assets or some new thing, that you can never have legislation which is actually all new and not covered by Section 6 at all?
Well, you could have all new, and if it derogates further and there's no existing law in place, well, of course, the Constitution bites in any event. I'm simply talking about the scope of Section 6.2.
What do you mean with there's no existing...
If you have, let's say, artificial intelligence, laws to do with artificial intelligence.
So if you're talking about sort of landlord or tenant or employment law, contract law, tort law, that's all, however drastic the changes that there are to it, it's never going to be outside 1C, 6.1c.
Well, of course, if they are drastic, but they don't derogate any further at all, then you're within Section 6.1c. Because alters, essentially, is given a very wide meaning. Alters includes the three. So alters is not just the three things I've mentioned, but alters includes anything which can properly be said to be an alteration. My lady, I can see there might come a point where you say, this isn't altering the 1954 Landlord and Tenant Act. It's so different that I can't even sort of make sense of it as such. But in my submission, alters is a wide word. If you had, let's say, a new act dealing with business tenancies, replacing a 1954 act dealing with business tenancies, that could well, in my submission, come within Section 6.1c, no matter how many alterations it made, because it's the same subject matter. But, my lady, that I think my submissions were not in that territory, because I fully accept we're in Section 6.2 territory. And what I have to persuade this court of is that there has been a repeal, which I submit is easy, and, quote, a re-enactment with modifications. And that is the essence of the debate. I fully accept that it's not enough for me to say there's a modification. It's not enough for me to say there's a different provisions in place of the old. But that's the question. And my lords, my lady, I do submit, of course one must give, it is said, a narrow construction, so forth, to derogations from rights, such as these types of clauses. But I do emphasize, going back to the case of Hughes, it is in case where there's, quote, in the case of doubt. It's not just, as it were, well, I can sort of twist the words this way and twist the words that way. There has to be real doubt, and that, in my submission, means as to what was intended, as objectively intended, by the Constitution.
That's the Lord Roger case.
That's Lord Roger. That's the Lord Roger case, yes. In the event of doubt, well, I think if in doubt, but my lords, my lady, I do submit that sometimes one reads these cases and you begin to wonder whether they're sort of pretty well saying, if I can do anything to override a savings clause, I'll do it. That, in my submission, is not the law. It is very important to give effect to the intention of the draftsman, in particular where they've obviously gone to some trouble to save Parliament in the event that it passes a new law which goes too far. Because the manifest intention of Section 6.2, in my submission, is to say, effectively, even if Parliament goes too far and gets it wrong, and it makes a further derogation, you just go back to what was there before. That is a strong, and I'm speaking in general terms, but that is a strong thing to do, and as far as I'm aware, my lady, my lords, unlike anything else in the other constitutions you will have seen.
What's substituted might be compliant, or it might be not compliant, but a less serious derogation. So unlike the ordinary process applying Section 13 of the Constitution, if you find something is not reasonably justifiable, you have to rewrite it to bring it into compliance, into compatibility.
The court has to do the rewriting.
Yes, whereas here you say you rewrite it, but it can still be incompatible as long as it's only as incompatible as it was previously.
Yeah. And the important words, I'll come to this in Section 6.2, are shall substitute, not may, shall. You've got no choice, as it were. The court has no choice.
I think you just said, I may have missed it because you. Yes. I think you may have dropped your voice slightly. Did you say this was a unique provision, as far as you were aware?
As far as I'm aware, it is unique. Yes, and I'll, if I may, I'll come to the genesis and the as it were, the problem in the Court of Appeal in Trinidad in 1973, 1974, which one can see led to this provision. One infers led to this provision. Because the old savings clause in the 1962 Constitution had nothing like it, and on the contrary was very limited. But I do submit that is important as part of the general background in applying what you might call the narrow construction. There are limits to narrow constructions, and if one can tell there's a conscious change and a major point, it is, in my submission, wrong, so to speak, to apply what you might call the extremely parsimonious construction that sometimes one has seen recommended, not by this board, but in other jurisdictions, to savings clauses. My lords, my lady, with that I'd like to go to the 1962 Constitution, and that, if I may, it's a bundle of authorities 2, I think. 1915. This is the Order in Council, 1962 Order in Council, pursuant to which the 1962, I think it's called the Independence Constitution, was passed, but the Crown was still the head of state. But subject to that, there was full independence in passing laws. You can see 1915 is the Order in Council, and Section 1.3 of this Order in Council, save where the context otherwise requires expressions used in this order, have the same meaning as in the Constitution set out in the second schedule to this order. And the provisions of Section 105 shall apply for interpreting it. You then go to the Constitution, which begins at 1925.
So with this Order in Council, it followed on, I think, from the 1961
yes,
order.
Yes.
And was the thought that if you just revoke the 1961 order and have the 1962 order, all the legislation that had been passed under the 1961 order would all cease to have any binding effect unless it was saved? Was that the concern that this is meeting?
It may be, yes.
The foundation of all the existing law on the revocation of the law-making powers in the 1961 order would evaporate, and there they would be without any legal foundation.
Well, a potential concern to that effect, yes.
Yes, but that's what this is
one presumes that's what this is doing, yes. You go to 1925, and you will see the endorsements, or rather the declarations, which you're familiar with from many other cases. 1925, whereas the people have affirmed, and you will see that goes over to page 1926. This is, for your note, in exactly the same terms as the later 1976 Constitution. Just one thing I would wish to emphasise, in 1925A, is that, and this goes more to the second point about reasonable justifiability, one does have to take into account that this is not an entirely Republican constitution. It is, if you go to A, people of Trinidad and Tobago have affirmed that the nation of Trinidad and Tobago is founded upon principles that acknowledge the supremacy of God, faith in fundamental human rights and freedoms, the position of the family in the society of free men and free institutions, the dignity of the human person, and inalienable rights. Now, of course, one might say, well, these don't necessarily all lead in the same direction, but I do submit it's quite an important point, and certainly would have been seen in 1986 as quite an important point, that this is quite a relatively religious and conservative society, and that, I submit, is recognised in the preamble to the Constitution. Section 1, 1926, you have, I think, again in the same terms as you later see in the 1976 Constitution, the recognition and declaration of the fundamental rights. And then Section 2, subject to the provisions of Sections 3, 4 and 5, no law shall abrogate. Now that's in materially the same terms as what you see later in Section 5 of the 1976 Constitution. Save the words right at the beginning, subject to the provisions of Sections 3, 4 and 5. And then you get to Section 3 at 1927. Sections 1 and 2 of this Constitution shall not apply in relation to any law that is in force in Trinidad and Tobago at the commencement of this Constitution. And then 2, for the purposes of subsection 1 of this section, a law in force at the commencement of this Constitution shall be deemed not to have ceased to be such a law by reason only of A, any adaptations or modifications made thereto under Section 4 of the Constitution Order. My Lords, my Lady, that relates to things like changing Governor General or alterations of names, but nothing material. The important point is Section 2B. Its reproduction in identical form in any consolidation or revision of laws with only such adaptations or modifications as are necessary or expedient by reason of its inclusion in such a consolidation or revision. My Lords, my Lady, you may be familiar that, with the process in Trinidad. Every 10, 15 years or so, there's a revision of the laws, and there's a power given to the person who makes the revision, so to speak, to cut out dead bits or things that don't matter, or rephrase things, as long as it doesn't change the substance of the text. You might think that, to us, might seem rather a bold thing, because if you change one word, you can often change unintentionally change more than you think. But anyway, that's the process, and that is what is anticipated in subsection 2.
So the 1980 consolidation that we have isn't in itself is the result of a legislative process.
No. As I understand it, it's the law reviser, so to speak, exercising his very limited powers of what you might call putting into better shape, but with the same meaning, or putting into modern language, but with the same meaning, what was there before.
Thank you.
So you're saying that's consolidation and statutory revision.
Yes.
Is what we're talking about there.
In 1980, yes, that's what's really going on. And it didn't cross anyone's mind that this was in any sense a repeal, or it was just the law reviser, so to speak, making alterations.
And who is the person that's authorised to make those changes then?
I should know, my Lord. I think there's a law revision commission.
So we have the same sort of thing here, that they suddenly realise that sleepwalking is still a crime or something, and it's
Yes.
cleared out by a general piece of legislation that tidies
Yes.
things up.
I'm not sure they can actually get rid of crimes, but they can certainly do things like remove the difference between felonies and misdemeanours, which gave rise to a lot of problems. But they have certain very limited powers. But basically, just to put the law into modern language, but not to change its substance at all. But here you'll see Section 3(2) appears to give only a very limited protection. And there may be more than one argument about it, but what eventually happened, in case I'll come to, was the Trinidad Court of Appeal said it's a very limited protection that you're given by Section 3(2)(b). I should also take your attention to Section 1976, Section 105, the definition of law. And under the heading interpretation,
Page
1976. Section 105(1). In this Constitution, unless it is otherwise provided or required by the context, then you have various definitions. Quote, law includes, I emphasize, includes any instrument having the force of law and any unwritten rule of law, and lawful and lawfully shall be construed accordingly.
So you say that includes the common law?
Yes, and that includes the common law. And I'll come to the slightly different, I think, equivalent provision in the 1976 provision in a moment. Now,
well, I thought we were in the 1976.
No, we're in 1962. Forgive me, Michael.
I misheard you.
Still in 1962. Now, there are just a few points which we mentioned in our case, but if I can just run through them to note about this Constitution. First, unlike, I think, virtually all the other Caribbean countries, it does not adopt the scheme of the European Convention on Human Rights. For instance, Jamaica, Barbados, Bahamas.
Are we now talking about, I know that some fundamental rights are the same, but are we now talking about 62 or 76?
Both, because 76 repeats the basic pattern of 62.
Yes.
Subject to the savings clause. And the scheme that's followed is a model adopted from the Canadian Bill of Rights, which sets out these rights in absolute terms. And this has been addressed both in Chandler and in Suraj, where the court makes this observation. This board has made this observation. So what you've got is apparently absolute rights subject to an existing laws clause. Now, this was the subject, shortly before the 1976 Constitution, of some criticism. If I can ask you, please, to go to page 3.
So you're saying that what qualifications there were as to those absolute rights, you had to look at existing law, whether written or unwritten?
Yes. Yeah, exactly. But they weren't expressed, as it were, with qualification. You wouldn't have individual rights subject to a qualification in each case. You have absolute rights, as it were, subject to this qualification in Section 3. Now, this scheme was subject to some criticism by the Wooding Commission. I think Mr. Justice Wooding had been Chief Justice of Trinidad and Tobago shortly beforehand. But anyway, he writes a report with a view to a new constitution coming into place. And if you go to 3836... I think it's right at the end.
End of what? Is this his report?
3836.
This is his report?
This is the Wooding Commission report, yes. It begins at 3804. It's at tab 68 if you're working by reference to hard copy. 3804, a report of the Constitution Commission, presented 22nd of January 1964. And you'll see at 3807, you'll see that you'll see the genesis of this report. The idea being that there's going to be a revision of the Constitution. You'll see that in the first paragraph, at page 3087. Now, one of the things he addresses is the structure of the 1962 Constitution. And you can pick that up at page 3836. It begins at paragraph 73, but paragraph 78 deals with the rationale of the existing provisions. These problems have arisen because the Bar Association's view prevailed that the fundamental rights and freedoms should be briefly and simply stated. That's i.e. in the old Constitution. Objection was taken to the original draft of the present Constitution, which set them out in much the same way as the ECHR. So the Canadian Bill of Rights was adapted without fully appreciating the difficulties inherent in altering what was a general code of rules for interpreting statutes, so as to become a positive affirmation of fundamental rights. In so doing, the present Constitution, I think he's talking about the 1962 Constitution, adopted an approach which reflects, the present Constitution, I think he's talking about the draft he has come up with. So when he says in so doing the present Constitution, he's not talking about 1962, he's talking about the draft which they've drafted, adopted an approach which reflects the thinking in the United Kingdom. There, no written constitution exists. All individual rights have their roots in common law. These rights may be defined as the area of permissible activity when all the laws restricting the individual have been taken into account.
Sorry, I think he is perhaps talking about 1962 with the present constitution. It was at paragraph 80. This result was achieved by the expedience of section 3.
Yes, my Lord, you're quite right. Yes, you're quite right. Forgive me. Yes, the present, he is talking about 1962. He says, these rights may be defined as the area of permissible activity when all the laws restricting the individual have been taken into account. Thus, freedom of thought and expression has always existed in Trinidad and Tobago, but everyone knew, without its being explicitly stated, that this freedom was subject, among other restraints, to the law of libel and slander, to the sedition ordinance, to laws against obscenity, and so on. This result was achieved in our present Constitution by the expedient of Section 3, which in a comprehensive provision made all the declared rights and freedoms subject to all the laws in force in Trinidad and Tobago at its commencement. Also, because there was from that time onwards to be a written constitution guaranteeing those rights and freedoms, from abridgment or infringement, provision had to be made for validating future laws which might appear in any respect whatsoever to be a breach of that guarantee. Hence, Section 5, with its safeguards, both an affirmative vote and so forth. And then, towards the end of that paragraph, the effect was indeed to produce a brief and apparently simple statement of rights and freedoms, but the brevity and apparent simplicity were misleading. Many people were shocked to find out that their rights and freedoms, set out in absolute terms, were subject to important limitations, the extent of which were nowhere defined. That led some people to wonder, perhaps cynically, whether there was any meaning to these rights and freedoms at all. And then the report continues, we are convinced that it is wrong to set out rights and freedoms in absolute terms, defining them as fundamental, and then to provide that Parliament may pass laws declaring that they shall have effect notwithstanding those rights and freedoms. Concept may well be seriously questioned if Parliament finds it necessary or prudent to pass such laws with any frequency. Indeed, the position in our view is made worse when some of them, far from being restrictive, are plainly beneficial in that they make available social and economic advantages never before enjoyed. We therefore think that it is better to define the rights and freedoms not in absolute but in qualified terms, so that everyone should know and understand that they are limited in scope. At the same time, the permitted qualification should not extend beyond what is reasonably justifiable in a society having a proper respect for the rights and freedoms of the individual, or during a period of emergency beyond what is reasonably justified, for the purpose of dealing with the situation existing during that period. And then the content and scope of the new provisions. Accordingly, we recommend that the new Constitution should adopt the pattern of the ECHR. In so doing, we reverse the decision taken in 1962 on the recommendation of the Bar Association and fall in line with all other Commonwealth Caribbean countries, having a written constitution and many others beside. Special provisions should be included to have effect during public emergencies. And as can be seen from the draft of the new constitution submitted with this report, each right is broadly defined and then are set out heads of exception under which laws can be passed, which will not be deemed to be an abridgment of the substantive right. And then it continues in the same vein until I think you get to... until you get to 86.
just before we get to 86.
Yes.
Is the draft to which he refers substantially the same as the 76 Constitution? As
no, very much. that, in a sense, is the point of my submission.
So we're really looking here at a hoped-for reform which didn't happen.
Very much the opposite happened.
Yeah. Okay, understood. I thought that's where we were going, but I just want to be sure.
No. So paragraph 86 at 3839, we have not included in the draft any clause preserving existing legislation. Where an existing law abridges or infringes a fundamental right, its validity will depend on its falling within one or other of the permitted exceptions, and also on its satisfying the test of what is reasonably justifiable in a society with a proper respect for rights and freedoms of the individual. It will not, if enacted before independence, have had to be passed by a 3/5 majority. That requirement will only apply thereafter. Then it goes on to say how you can then challenge laws. Paragraph 89 I should take you to. It will also be possible to challenge existing laws which may be thought to abridge or infringe the fundamental rights and freedoms as they've now been defined, since there's been no wholesale adoption of the pre-independence body of law. It seems only proper that citizens should be able to test such laws against the standards which the society has elected to adopt. Now, the second point, so I say this is what's happened in 1976 is a direct contradiction of what was recommended, and one has to bear that in mind, especially in my submission when you come to Section 6. The second point, on the 1962 Constitution still...
So, Wooding was recommending that you don't distinguish between existing laws and subsequent laws. It was all just going to be subject to fundamental rights.
Yes, and reasonable justifiability and so forth, yes. But no special protection for existing law at all. Yeah. So even what you had in Section 3 was to go, and even though Section 3, on one view at least, is not a terribly potent existing law provision, because it basically would appear to allow you to go, it would appear to cover only those alterations which appear in a revised edition of the laws, but not anything else. I'll come to that in a moment.
So for what purpose relevant to our work today is this cri de coeur that wasn't accepted being prayed in aid?
Because it goes to show, especially with the case I'm going to come to, that the purpose of the 1976 Constitution, and especially Section 6, was to firm up, and substantially to firm up, on the protection given for existing laws. In two respects. First, the first respect is any alteration of the existing law, as long as it derogated no further, was fine. That's Section 6.1, essentially. And then the Section 6.2 point. If Parliament gets it wrong and goes too far, never mind about that, you just go back to what was there before. So it's very much a conscious decision by the framers of the Constitution to adopt and to firm up on the existing law provision, to give more protection, not less protection, to existing laws than in the 1962 Constitution. My Lord, just briefly, before I go to 1976, the second point I wanted to make was that Section 6.2 of the 1962 Constitution was expressly said to be, quote, subject to Section 3. And my lords, my lady, we say it was recognised...
Can you just give me the page? I'm sorry.
Oh, yes. 1917.
1917.
And...
Say that again. Section
2 of the 1962 Constitution was expressly said to be, quote, subject to Section 3. 1926. And we accept and we say that it was therefore recognised in the Constitution itself that there might be some laws which did, in fact, abrogate, abridge, or infringe the fundamental rights. And there is authority to that, and we recite this. There are two cases which say that the premise of Section 2 and 3 is that there may be some laws which infringe the rights. And one is the decision of Mr. Justice Justice of Appeal Phillips in the Trinidad Island case, which you can find at 2986.
Well, that rather begs the question of the scope of the rights, doesn't it?
Well,
the scope of the right is just to say anything that you want. But then you're saying, well, is it an abridgment or an infringement of that right to say, but not if you're libeling someone or not if you're inciting someone to racial hatred? Is that law that creates the libel exception to freedom of speech? Is that regarded as a law that infringes that right?
My lady, no, I don't think that's what certainly Mr. Justice of Appeal or Lord Diplock in another case had in mind. I think what they were envisaging was, it's perfectly, the Constitution proceeds on the premise that there might be some laws which do, in existence, which do actually abridge the fundamental rights, notwithstanding the declaration, which you see right at the beginning, which say they have existed from time immemorial, and so on. So it was recognized, even in relation to the 1962 Constitution, that some laws might abrogate from some existing laws might abrogate or abridge the existing rights. The other reference where you get the same point being made is by Lord Diplock in the case of Maharaj against the Attorney General number 2, which you will find at the relevant passages at 2637 to 2638. But nonetheless, it was held that the effect of Section 3 of the 62 Constitution was to prevent any challenge at all to the existing laws. And for that, there's a passage where Lord Diplock makes that plain in De Freitas and Benny, and you can find that at 2592G. So that was the effect of Section 3. The third point I want to make, which I've already made, but just to emphasize it, was that Section 3 gives very limited protection, indeed, on its face. And the fourth point to note about the 1960...
So had we been dealing with this Constitution...
Yeah, I'll be out.
You're straight out.
Wouldn't be here. No.
Well, it gives absolute protection to existing law, but nothing else.
Yeah, nothing else. But it's also got a very, very limited definition of what equals existing law.
Yeah, and you say it covers consolidation and revision, but that is all.
Yeah, and I'll come to a case where very shortly before, in 1974, where the Attorney General got stung, if I can put it that way, on the narrowness of Section 3. The fourth point about the 1962 Constitution is that there was no supreme law clause, which one does find later in the 1976 Constitution, which provides that a law that's inconsistent with the Constitution is, quote, void to the extent of the inconsistency. There was no such provision in the 1962 Constitution. Now, I come now to...
But if the Constitution was to be of any use, something like that must have been implied, mustn't it?
Well, yes, it might have been implied, but to what extent? Void to the extent of the inconsistency might be said to be going rather, which is what you find in 1976, might be said to be, by implication, and to the extent not inconsistent, not void. But my Lord, in any event, there wasn't an express clause, which you now find in Section 2. Now, there was a Court of Appeal decision, which one sees, if I may take you briefly to, at 2962, at tab 46, called Trinidad Island-wide Cane Farmers versus the Attorney General and Syria. And before I go to the relevant passages, if I can just briefly, it's quite a complicated case, but if I can briefly summarize what the point was. A cane farmer sold sugar to an association, and he was deemed thereby to be a member of the Trinidad Island-wide Cane Farmers Association. So because he's selling sugar, he's deemed to be a member. And he's also deemed, by reason of an amendment passed in 1973, he's liable to pay a tax or cess of 20 cents a tonne from the sums which are payable back to him. So he's got to pay a tax or a cess of 20 cents in the dollar. And that 20 cents was much greater than the 10 cents a tonne, which had previously applied under a 1961 ordinance. So you have essentially a 1961 ordinance, which provides for 10 cents a dollar. You then get the 1962 Constitution. And in 1965, there's an act which basically repeals and then re-enacts substantially the same way the old 1961 ordinance. And then in 1973, the cess is increased to 15 cents from 10. And the judge at first instance had held that the 1965 Act was a valid act, but the 1973 amendment, which bumped up the cess to 15 cents in the dollar, was invalid because it forced him to pay a cess and infringed his right to due process. That's the essential line of argument. If I can go to the case itself at 2965C, it's the judgment of the Chief Justice Hayatali, 2965C, if I can just give you the chronology here. But you can see in the second paragraph, on the 1st of September, the Cane Farmers Incorporation Cess Ordinance was enacted. That's part one. And that effectively, you can see what the effect of that was. If you look at the last 4 lines, it deemed as members of the association every cane farmer who entered into a contract to supply canes to a sugar manufacturer, and every cultivator as defined and every cane farmer. And then after you have the 1965 Act, which is referred to in the final paragraph. On the 2nd of February 1965, Parliament enacted the Cane Farmers Incorporation Cess Act, described as an act to amend and revise the law relating to the Trinidad and Tobago Cane Farmers Association and for the purposes incidental thereto. The provisions of the 1961 Act with respect to compulsory membership, entitlement to resign and so forth were repeated. In addition, several changes were introduced, but they were of such a character as to make the 1965 Act in the final result a, quote, substantial reenactment of the 1961 Act. And then, for present purposes, one can just go to page 2967, where you go to the amendment which is made by an Amendment Act in 1973, second paragraph of 2967. On the 7th of June, 1973, the Amendment Act was enacted, repealed Section 17 of the 1965 Act. It introduced not only a substantial alteration in the manner and method of imposing the cess, but increased the maximum amount imposable to 20 cents. So that's the sequence. Now,
it's per tonne, not per dollar.
Sorry, but per tonne, yes. Yeah. But sorry, forgive me, my lord. Yes. Now,
Mr. Knox, are you about to sort of take us into the guts of this?
Yes.
I wonder if perhaps we might defer that until 2 o'clock.
Of course, my lord, yes.
Very well. We'll adjourn just now and resume at 2 o'clock.